Good afternoon and welcome to our first ScholarShare webinar series of the academic year, Unlocking Innovation, the Strategic Role of Patents in NAI Programs. I'm Jamie Renee, and I have the honor of serving as the Executive Director of the Academy. I'm pleased to introduce you to our speakers, Anton Hopen and Julie Akhter. Anton Hopen is the Managing Partner at Smith Hopen, where he practices intellectual property law with almost 30 years of patent law experience. He also is the founder of Innovation Express, which teaches young students about intellectual property law. Thank you, Anton, for sharing your knowledge and experience with us today. Our second speaker is Julie Akhter, recently joined the NAI team as our Senior Director of Programs. Julie is also a patent attorney. She came to NAI after serving for 13 years at Microsoft, where she led a patent group to build and license Microsoft's patent portfolio. Before Microsoft, she worked as a patent attorney in private practice in California. Since joining NAI, Julie has jumped right in on leading several of our programs, and she's excited to tell you more about them and how they're designed to support our members. With that, I'll hand it over to Anton to get us started, and I just want to let everyone know that the Q&A portion is open on Zoom, and we'll be sure to get to as many of your questions as we can. So feel free to use that feature while our presenters are providing information. Thank you. Anton?
Thank you. Good afternoon, everyone. It's a pleasure to be here. Just to give you a little bit of overview of what we're going to talk about is what is intellectual property, what is its value, a little bit of a narrative of a very well-known company's experience, and how that evolved into kind of the current landscape that we have, particularly in patents, the constitutional basis, a little bit of the history of patents in the United States, and then we're going to kind of wrap up and do some practical analysis of what is a patent claim and how you can interpret it. So the other thing is, throughout this, we've got a few polls where we're going to be able to pop up and kind of get your feedback on sometimes a quiz and sometimes what might be your opinion. So I hope it's engaging. We're going to go fast paced and hopefully give you some practical knowledge to walk away with. The one thing that we can start, and Julie, if we go to maybe the second slide, I want to talk a little bit about the types of intellectual property there are. So I always say these are the four horsemen. So we have trade secret, copyright, trademark, and patent. So we're going to end with patent, but we need to have a little bit of a context and a frame of reference of what intellectual property is. So we'll start with the next slide, which is trade secret. And just an example is a trade secret is anything with economic value that is kept confidential. So it could be client lists, customer lists, secret formulas to Coca-Cola, or it could be massive amounts of technical data that you might be using to train a model using machine learning. So in this case, Dojo is a fairly famous supercomputer used by Tesla for full self-driving machine learning. That billions of miles of video data, the additional work of Tesla employees to label that data, that this was a good turn in the intersection, this turn ended up as a crash. You have to have context to your data. Extremely valuable in trade secret protection. Just a few years ago, we actually had a federal trade secret protection act. So to a certain extent, trade secret, I think, is ascending as a valuable portion of intellectual property. So our next type, we'll go to the next slide, is copyright. So I'm just going to stick with my Tesla theme here. And copyright protects anything artistic expression reduced to tangible form. And when it's tangible form, it could be pressing that key stroke on your keyboard, and that's recording a 0 or a 1 bit in your computer to record that creative expression. In this one, we see a Tesla employee, which is a work for hire, created a sculpture, which is in 3 dimensions, of the little dog when you put your Tesla on dog mode, so people know not to break the window to pull your pooch out of the car. One thing about copyright is, if you can protect something with copyright, the deck is so unbelievably stacked to copyright owners. It's no secret that very strong lobbyists push for extension of the Sonny Bono Copyright Act. So if we look right now, this copyright was deposited and published in 2024. It will not expire until February 17th, 2119. We'll probably see that dog on a spaceship on another planet somewhere, and it will still be enforceable copyright. The key thing about copyright is it's one of the only things where I would say a layperson, a non-attorney, can do it actually very well. You go to copyright.gov, you take your work, which is usually a PDF. In this case, it might be a video clip. You deposit it, you pay with your credit card. Now, if you do that within 3 months of publication or before actual infringement, and you never know when infringement's going to happen, but as long as you do that within 3 months of publication, when you go to court, you can elect statutory damages, attorney's fees, and court costs. Statutory damages are the big thing. So if any of you have been around for 15 years, you remember Napster, where people were file sharing movies and music files, and you would have soccer moms getting hit with $13 million judgments from the Recording Artists Industry Association. And they were doing that because every time there was a mechanical copy and it was willful, it can invoke that $150,000 statutory violation. Otherwise, if I don't do this simple copyright deposit, then I go to court and I ask the judge, I prove my case, substantial similarity, and then the judge says, what do you elect? And can you elect statutory damages? No, Your Honor, I didn't file it in time. So he said, well, put on your case of actual damages. Well, that soccer mom didn't damage really anybody. So the recovery would have been very, very low. And also I would be paying my expert witness $1,000 an hour, and then the other side would be paying their witness $1,000 an hour to tell each other they're lying. So copyright, amazingly powerful. That could be another lecture, but it protects artistic expression reduced to tangible form. But also think when we start to head into patents here, what's the first four characters of copyright? It's copy. So there has to be a copy. We can't independently create these works and then there still be copyright infringement. So you have to either prove actual copying or basically set the circumstantial evidence so there's no other reasonable explanation for that. So we'll move to the next one. And so trademarks protect the identity, a single source or origin of a product or service. And so think of this synonym for trademarks is brand, right? And you think of a cattle rancher that's going out and it has a steer. And if that steer wanders off and somebody finds it, if there's no brand on it, nobody knows the origin. Nobody knows where it came from. So that's why ranchers for hundreds of years steered a very unique design on each of their steers. And then when it wandered off, we would know, oh, that's rancher Julie's cow, and we can take that cow back to her ranch, and we know the source or origin of that product or service. And so in this case, what's really interesting is a lot of times you can play the future card, and you can look at the U.S. Patent and Trademark Office, search a company, and you can see what they might have in the pipeline. So in this case, we search Tesla, and we know that there might be, it's not a committed, that there might be a cyber beer, a giga beer as an alcoholic beverage, a cyber hammer, which is an exercise device that takes the form of a hammer, like a kettlebell, candy that is branded Dog Mode Chill, Mango Bolt, or Supercharged Gummies. And then finally, Tesla actually branded a brand. And this is something where you can heat it up and sear it onto something. And if you look at the specimen, which is a little photo on there, it says made on Earth by humans, which I don't think they can trademark that because that would be a generic description of something made on Earth by humans. So again, trademarks can be incredibly valuable. They can be worth billions of dollars, the goodwill that's associated with them. But again, these are the three different types from patents. Now we're going to get into patents. So we'll go to the next slide. And so let's take a look at a utility patent. And here we're looking at a battery chemistry for difluorophosphate. And this, again, I'm just sticking with my Tesla theme here. This would be a utility patent. It's one of the three main types of patents, but probably the one you think of the most. It is protecting the functionality of something. It can be a chemical composition. It can be a mechanical object. It can be a process. It can be a method. The only blowback that we tend to get is when it starts to be considered an abstract process or an abstract idea, a method of arranging human activity, things like that. From the 2000s, we had a ton of patents from the dot-com boom. These patents were attempted to be monetized by a ton of litigation. The Supreme Court finally took that case in 2014 and in the summer and said, look, just because you took something that everybody knew how to do and you put it on a general purpose computer does not automatically make it patentable. And by doing that, you would preempt all this innovation in the field. So by analogy, it would kind of be like Thomas Edison coming there and saying, well, I'm going to claim all artificial illumination. Well, then, yeah, you may have done the incandescent light bulb, but now Thomas Edison, if we allowed him that, we wouldn't have the compact fluorescent. We wouldn't have light emitting diodes. So the careful thing that the courts are trying to push back in is to make sure that, hey, if we're going to give you this patent, we want to make sure that it's fully enabled, and we want to make sure that we're getting our, bargain for exchange back. So in this case, one thing on utility patents, we have to enable it in sufficient detail so that one of ordinary skill in the art can reproduce it without undue experimentation. Patent attorneys say that phrase in their sleep. Okay, the next type of patent we'll move on is a design patent. So if we look at this, this is the Tesla semi-truck design. And what a design patent does is it protects the aesthetic ornamental shape of an article of manufacturing. So it might be the flares of a Coke bottle that don't serve any purpose other than the aesthetics. It doesn't create a better fluid impermeable container. And then you might look at like a mailbox that's shaped like a football. And in Europe, we call it industrial design. But basically, it's a wonderful melding of art and technology together. And the design patents we'll talk about a little bit later actually really became a valuable asset in a lot of very high stakes litigation. Now, one thing to be careful of is the scope of a design patent. When you see a design patent that is in all solid lines, and there is basically what we call no environment, it might not be worth the paper that it's written on, but I'm going to teach you guys that, how to spot a good design patent from kind of a one that is not particularly legitimate. So finally, let's go to the last type of patent, and this is a little bit more obscure, and this is called a plant patent. Oh, I had some secret animation in there with the Tesla semi truck. No one knew about that. But the plant patent is pretty unusual, and I would suspect that maybe if you're lucky, 1 out of 100 patent attorneys have ever gotten a plant patent. And I feel very privileged to say that our firm has, because we represent um, one of the best organizations in the country, which is Florida Agricultural Mechanical University, and they do amazing technology in cultivars. So the hook with the design patent is you have to create a new cultivar that can be reproduced asexually. And so you'll see a lot of more of this in maybe the Midwest, in cultivars and wheat and things like that. But plant patents, 20-year term, just like the utility, but no maintenance fees. So you get a plant patent and that's your business, then that's wonderful to do. But within the umbrella of intellectual property together, it is an incredible benefit to our economy and to our country. And let me explain that. There are about 45 million employees in the United States that are in IP intensive industries. These are not just engineers and chemists and scientists, but they're content creators and they're technologists. And they're creating new content, and they're actually paid 46% more on average. We export about $1 trillion of intellectual property. We're not just talking about the physical manifestation of the technology. We're talking about the licensing that's coming back into the United States and benefiting our economy just through the intellectual manpower and creativity and innovation of the people that work in this economy. So in the United States, just internally, the intellectual property is believed to at least generate about 6.6 trillion per year. So the numbers are absolutely amazing. We're so privileged to live in a country where this fundamental concept of protecting the intellectual property as a property right is embedded into our Constitution. And we have one of the best infrastructures in the world. You're looking at the UK, United States, Singapore, Japan. These are all highly industrialized countries, low levels of corruption that will protect the intellectual property so that you can secure it and you can enforce it. When a country has difficulty, Venezuela, Syria, one of those, there's virtually no chance to protect that intellectual property. And when you can't protect the intellectual property, it's very difficult to get large companies to come in and invest into your company. So it's a bit of a catch-22. So to have a high level of civilization, to have a high level of GDP, of quality jobs, of high income, it's very important that that intellectual property system remain intact. And so we'll go to the next slide. So I like stories because stories really help me remember things pretty well. So this is a little bit of a narrative of Microsoft's journey through the patent system, and it's just a few select cases. I'm not scratching the surface of the depth of Microsoft's uh, um, uh, successes and entanglements with intellectual property, but this shows a little bit about how the patent system works and why we want to get patents. And I want to make one very important point. And that point is you have insurance for your house in case it burns down. You have insurance on your life so that your spouse and your families and your partners can survive after your death. You have insurance for your car in case you get in a wreck. And all this insurance is invoked when something bad happens. But patents are also insurance, but it's the reverse. You don't need a patent if your company fails. You don't need a patent if your chemical formulation is no good. You don't need a patent if your composition in pharmaceutical doesn't make it throughout the trials and the FDA doesn't approve it. You need your patent when you're a success. You need your patent when you took risk after risk after risk and failed, and then you finally succeed. So patents are this unusual insurance policy for success. So the fact that you might be interested in patents or the fact that you have patents intrinsically means that you're probably fairly confident, intelligent, ambitious, and positive person because you're looking to the future and you envision success, because that's the only reason that you're going to get a patent is because you have a reasonable expectation of success to the future. So let's talk about Microsoft. So Guatemalan Carlos Amado invented a technology that exchanges data between Microsoft Access and Microsoft Excel. It's hard to believe that they didn't talk to each other, but we're talking back in 1990, and he patented this. Microsoft was interested, and like Microsoft, what Microsoft does is they undergo due diligence and they look under the hood and they figure out how somebody's doing something and they decide if this startup, Mr. Amato's startup, is a good fit for Microsoft. Well, they ended up going through talks in 1992, but by 1995, Microsoft just went ahead and released the feature. Well, Mr. Amato was just beside himself and turned around and sued Microsoft for $500 million. Well, Microsoft was found not to be willful. Otherwise, that judgment could have been very, very high. But the court still awarded Mr. Amato $8.9 million. So Microsoft would have been better off licensing the technology. But if Mr. Amato had not patented his technology, there would have been no recovery. So we're looking at the mid 90s, and we'll go to the next slide. Microsoft is 0-1 on patents. Okay. The next one, and I think this is going to be a poll. So in 1990, what was the typical hard drive capacity that you could acquire for around $500? And we'll just give you guys 5, 4, 3, 2, 1. All right, it's 40 megabytes. 40 megabytes. And So hard drive capacity in 1990 would probably not even hold this single presentation, much less the operating system and all the other things that we were doing. So hard drive capacity was a very limited feature. And so Microsoft ended up getting in talks in 1993 with a company called Stack Electronics. Stack Electronics invented a compression system that would actually double the capacity. So that $500 40 megabyte hard drive would actually give you the capacity of about 80 with a pretty low impact on performance. They were in discussions, but eventually Microsoft just ended up using the technology. And if we go to the next slide, it was released as double space, which is pretty descriptive about what it's doing. It's doubling the space. So it was a pretty valuable technology because you could quantify it. If I had to buy another hard drive, then that's $500 out of my pocket. Well, I'm going to multiply it by all the people that bought this. And so Stack Electronics had a pretty good argument. So the jury came back with a $120 million judgment against Stack Electronics. Now, Microsoft settled. They ended up investing $40 million into Stack Electronics. And then they also paid Stack Electronics $43 million in royalties. But again, had Stack Electronics not patented their technology, there really would have been no consequence to doing this. So at this point, we'll go to the next slide. Microsoft is 0 and 2 on patents. So then, and don't worry, Microsoft's going to come back really well in the end here. So in 1994, Toronto inventors created this new technology, and it was being able to mark up and edit XML documents. Those are extensible markup language. And for your techies, you know this, it puts the context to the data. So kind of looks like HTML. And Microsoft was in discussions with i4i Technologies. And it was a very small company, only 11 employees. But they did file for a patent, and it was granted in 1998. So Microsoft did not reach an agreement with i4i Technologies, but they just released it anyway as an additional feature of Microsoft Word. And i4i sued. They eventually even had what they call a re-examination at the US Patent and Trademark Office. This is kind of like a redo of the original patent prosecution. All the claims were affirmed, and this case was brought in the Eastern District of Texas. They came back with a judgment of $300 million. So this ended up going to the Supreme Court, and in June 9th of 2011, a unanimous Supreme Court, there were 8 justices there at the time, 8-0, affirmed the $300 million judgment. But they addressed probably an even more important issue for everybody that owned a patent. So as a former criminal prosecutor, I can just tell you this: I had to prove my case beyond and to the exclusion of any reasonable doubt. That was a criminal case. And so we have a very high standard of proof on criminal cases. Why? Because we don't like to put innocent people in jail. It's bad. On the other end of the spectrum, we have civil cases, which is a slip and fall or breach of contract. And in that case, nobody's going to jail, but we're going to set the presumption at a preponderance of evidence. So that's like tipping the scales, 50.00001% is if I can tip that scales by a preponderance of evidence, then I win my case. And then in the middle, there's clear and convincing, which is somewhere in between those two standards. So we're going to go to the next slide, which is a poll, and I'm going to ask you, what standard did the U.S. Supreme Court on June 9th, 2011 find patents to be presumed valid? So if that's not working, if that's not working, that's fine. So what they did is there was uncertainty in this. It was never going to be reasonable doubt. So if you check that, that was never going to happen. So it was really between preponderance, because patents are a civil case. Nobody goes to jail for patent infringement, but you can lose a lot of money. Clear and convincing is higher than that. And what the US Supreme Court said is look, unlike certain countries that have a registration system, very few in patents, South Africa might, where you just file your patent application, nobody looks at it, and you only pull it out and you litigate it if there's infringement. But in most countries, there's a substantive examination, and you have a patent examiner who acts as a wall, and he or she will not grant that patent unless it meets very specific and rigorous standards of patentability. So the US Supreme Court said, look, it's already gone through this process with a quasi-judicial officer who's an expert in patents. That's all the patent examiner does. So we're going to grant this clear and convincing presumption, the standard for patent validity. Now, what did that mean? This is June 9th, 2011. That's earth-shattering to patent holders. Okay, Microsoft is already 0 for 3. They already got tagged with 300 million. They can pay the 300 million and not fold, but now they realize that the door is open. It's going to be very difficult to invalidate every single patent now that the standard has a higher presumption of validity. Because when somebody sues you for patent infringement, the first thing that you counter is that patent's invalid. And if you really litigate and you have high quality counsel, you might even get those numbers to 50-50. Like every time somebody attacks you, you might be able to say that patent's invalid. So that's your compulsory counterclaim essentially. But now that standard is going to be higher and it's going to be more difficult to traverse. So if we go to the next slide, Microsoft is 0 to 3. And right now, this is perfect. Microsoft has some contemporaneous struggles. All right. It is not just losing patent case after patent case. All right. In 2011, there's a lot of transitions in technology. We have going from plain old telephone systems with the switches to voice over internet. And so Microsoft spends something like $8.5 billion to acquire Skype. Skype's not making them any money either. So they're losing money on Skype. Microsoft looks at PlayStation and they say, wow, you sell the hardware and then the kids get bored with the game after a month and buy another game and buy another game. We love this business model. But launching a console is very expensive and very difficult. And Microsoft was said to be losing nearly $2 billion a year on their investment in Xbox. In fact, the rumors, and everything's a rumor, is that they were trying to unload Xbox. And then finally, you have the Windows Phone, which honestly, you had iPhone and you had Android, and Windows Phone was a good effort, but it never took off. So Microsoft has got these 3 issues going on, and they're losing patent cases, but they're not dumb. Microsoft is actually very smart. So what Microsoft does is it does what it does best, and that's acquire things. So it goes back and looks, where can we go in the marketplace? Well, to know why AOL was attractive to them, you have to go back to 1985 when AOL was like the only way to get on the internet, and you were in the AOL ecosystem. And by by 1995, AOL had 3 million users, and these users were captive within their system. They didn't go out into the internet and browse randomly. That was the vast majority of that was through academic institutions that were kind of more cutting edge in that respect. AOL was generating so much money that in 1998 it bought Netscape, who is pretty much considered to be the founder of the web browser, and they bought Netscape for $4.2 billion. AOL was an 800-pound gorilla on the internet at this time, but there was a problem: broadband. So when you connected to AOL, you were using a dial-up modem, you were taking up your plain old telephone line, nobody could call you because they probably didn't have a cell phone either. And when broadband was introduced, it allowed users to get out of that ecosystem, which was like a Windows or Mac application, and they could go anywhere they want. They didn't need AOL as much anymore. And by 2012, AOL was just bleeding money. They needed help. So, and Microsoft comes in, and in April 9th, 2012, acquires basically paid up licenses, and we'll go to the next slide, to 800 AOL patents. So my poll question on this is, how much do you think on a per patent basis that Microsoft paid to AOL for each individual patent out of the 800? So when we feel like we've gathered enough, we'll go ahead and see what that poll comes out to. All right, you guys undervalued AOL. Microsoft paid $1 billion for that basically paid up license, not even an assignment, and that comes out to $1.25 million per patent. Now, just to give you a little bit of a context, like even today, it would be pretty normal to see a utility patent cost between 15,000 to 25,000 through issuance to acquire, depending on where you are in the country and the size of the firm and things like that. So that's quite a premium. But is Microsoft, do you think, oh, Microsoft is crazy? They're not smart. They're foolish for doing this, but they're not. And you don't bet against Microsoft in the long run. So if we go and we look to the next slide, Microsoft is a public company. It has to disclose through a 10K what's going on with its finances. And if we go to the next slide on the 10K, we see that it has got an incredible increase in revenue. And it says, due to Skype and Windows Phone and Xbox. And everybody is looking at that going, you've got to be kidding me. Xbox is still a loser currently. Skype is a loser. You paid $8.5 billion for it. Nobody's got a Windows Phone. Even the Microsoft developers are using an Android. So where is this coming from? Well, in the 10K, look what they did. I underlined it. It also included patent licensing revenue. Where were they getting this patent licensing revenue? It just seemed like Microsoft was getting sued by patent holders. It didn't seem like they had a big patent portfolio, but they did. They had AOLs. And what they had done is turned around and monetized their AOL patent portfolio against Android licensing. So HTC, and again, these are rumored, but HTC was rumored to be paying $10 per device to Microsoft for use of the Android system that Microsoft never developed, never wrote code for, but they had patent rights that implicated this. And then Samsung was rumored to be paying between $12 to $13 an Android device to Microsoft. And in sum, this was getting close to $3.5 billion per year. So was Microsoft foolish to pay $1 billion and then within 18 months turn around and create a patent revenue licensing income of $3.5 billion? And you should thank AOL because they indirectly saved the Xbox, which my children love. So the thing about Microsoft, and this basically stems from the June 9th, 2011 clear and convincing standard of the US Supreme Court. Finally, all these patents now have a heck of a lot more intrinsic value. They're far more enforceable. Now everybody is acquiring them. So we go to the next stage. And when we look at Apple versus Samsung, it's a legendary patent case. It had one of the highest judgments, if not the highest judgment at the time, $4.5 billion for Apple when it was concluded. Of course, that got whittled down and settled at some point. But by August of 2011, just 2 months after the Supreme Court decision, there were 19 litigation cases in 9 countries, and by the summer of the next year, there were something like 50 lawsuits worldwide, and they ended up getting consolidated. But Apple was suing Samsung, and if we go to the next slide, you'll see just an example. The Galaxy S was being sued for infringement of a design patent that Apple owned. And one thing to note very quickly about the design patent is you see all these hatched lines, that's called environment. And that basically just puts it in context. But what you have to infringe a design patent is the solid lines that are rendered. So we look at the button, it's got dashed lines, but the solid lines are where the screen are, where the little speaker is at the top, where it meets the bezel. We can go to the next slide and you'll see another design patent. And Apple was covering all its bases. So here now it's the bezeled edge. And design patents were great for the juries because they didn't have to get into the weeds of the technical experts. They just had to look at it and see if it looked similar. So if we look, you'll see what the jury verdict form looked like if you were on that jury of Apple versus Samsung, and you just had to basically say whether these were infringing each other. And we go to the next slide, it wasn't just the physical device itself, not just the corporal object, but it was actually the screen itself. So a graphic user interface, the first design patent for a graphic user interface was on an ATM machine. But here we had static icons at the bottom, which were kind of your most used text and phone, and then you had a canvas that you could swipe. And Apple was able to sue and recover for Samsung for the graphic user interface because that has been considered an article of manufacture. And if we move on, we see that verdict form as well. So when you look at a device that is sophisticated as a smartphone, you have the glass, the processor, the Bluetooth, the antenna, all these technologies that are coming together. There implicates about 250,000 patents. If all of these patents have 20 claims, then you have about 5 million patent limitations that you would have to analyze. And that would take about 2 million patent attorneys working full time in perpetuity to figure out whether one smartphone would infringe on the other smartphone. So this is what Apple and Samsung finally arrived at, was like, look, all we're doing is enriching the patent attorneys to the greatest degree ever. We're never going to resolve this because Apple, you're going to infringe on some of Samsung's, and Samsung's going to infringe on Apple. So now there's cross licensing, and we'll get to that as a benefit of the patent system as well. So we'll go to the next slide. So this started to reach in 2013 to 2014 a crazed level. So Apple and Microsoft, very strange bedfellows, they went and they acquired bankrupt Nortel's patent portfolio for $4.5 billion. Then they sued Cisco, Google, Samsung, and HTC. Now, the only public recovery that we know about was Cisco, which I would say is the smallest player, paid $188 million back to this consortium. Apple and Microsoft, they called themselves Rockstar together. And then Google ended up getting religion about this. And they said, well, look, we can't just be this target with a bullseye. So they went to Motorola and they paid $12.5 billion for the Motorola portfolio. So the litigation ended up getting crazy. But by 2014, the name of the game was cross-licensing. But for the big entities, these patent systems were incredibly costly. And I'll point out how this is relevant. And Julie, I'm gonna have to move on time. So why are patents granted? We're gonna go and move that they are a restraint of trade. So really the United States, we really don't like restraints of trade. We like freedom. We like the ability to do what we want. And so we're traditionally against monopolies. The most wealthy person in the world that ever existed was John D. Rockefeller, that in today's dollars would be about $700 billion. And he controlled Standard Oil, everything from the pipeline all the way down. And so they had to break them up because it was such a terrible restraint of trade. And if we go to the next slide, we realize that why do we do this in the United States? It's because it's a bargain for exchange. So Isaac Newton said, if I have seen farther, it's because I'm standing on the shoulders of giants. And what he is basically saying is, I took this and I improved it and I took it a little bit farther, but I'm not solely responsible for the concept as well. So the bargain for exchange we have between the US government and the inventor is you will have to disclose your invention. And in doing so, you help foster innovation and you help foster other people learning from your technologies, and we will grant you a 20-year monopoly in exchange for that. Because what is the opposite of the word patent? It's latent, it's to hide. So patent is to open up and disclose. And so if we go the next slide, it's embedded into our Constitution. And what is remarkable is when did we start issuing patents? Well, we had our first patent board in 1790. And so here's our poll question. Who was not on this patent board? Who was not actually examining patents? And you had Washington, Jefferson, Knox, Franklin, and Randolph. Which one of these was not on the original patent board in 1790? All right, so how did we respond on that? George Washington. Actually, it's so funny, George Washington was not only on the patent board, he was the one that signed the patent. And so it was Benjamin Franklin, ironically, one of the best inventors in US history, was not on the patent board. And they met the last Saturday of every month. 2/3 had to agree. They had an allowance rate of about 50%. And this continued until the new Patent Act of 1836. So let's see, I think, Julie, if we want to take a little bit of a break, I want to defer to you because you're going to talk about NAI programs, and I'll take a break for a minute.
Sure, that sounds good. Let me switch the decks really quick. All right. Well, thank you, Anton, and I'll try to go through this quickly to give you some time back, because I know there's a lot of really interesting information about coming up about patents, and I really enjoyed hearing that history of the patent system, and my background is in tech, so I'm very familiar with all of the Apple and Microsoft work. So it's cool to hear. All right. As Jamie mentioned, I'm Julie Akhter. I am the Director of Programs at NAI. And so I'm just going to walk us through some of the programs that NAI has that really are designed to support our community, our inventors, our member institutions, and let you know what we've got out there for you. All right, so here's a brief overview of the programs I'm going to talk about, some of the benefits, and I'll jump right into our first set of programs, which are our recognition programs. We have our Fellows Program, our Senior Member Program, and our Chapter Program. So the foundation of NAI is election and recognition of our fellows, which recognizes inventors affiliated with academic organizations, nonprofit research institutes, or government agencies who have made outstanding contributions to innovations in areas of patents and licensing, innovative discovery and technology, have had a significant impact on society, and the support and enhancement of innovation. Election to NAI Fellow is the highest professional distinction awarded solely to inventors. And I'm proud to share some of the accomplishments of our NAI Fellows. It's a prestigious and prolific group of inventors who have made a huge impact and continue to do so. You can find out more information on our website, including how to nominate others for fellowship, the minimum requirements for election, and more. And there's the link right at the bottom of the page. For those who are starting their innovation journey, we also offer the Senior Member Program exclusively for inventors affiliated with the NAI member institutions. These are rising stars who foster a spirit of innovation within their communities and institutions while educating and mentoring the next generation of inventors. And they're a quite impressive lot themselves, holding over 5,700 patents with almost 2,000 of those licensed. In addition to our Fellows and Senior Member programs, inventors can also get more involved with NAI through chapters at their member institutions. Over 50 of our member institutions have chapters with more than 2,600 members, creating a network dedicated to facilitating innovation and celebrating inventors at their respective institutions, as well as on the local and regional levels. Bringing together inventors in an institution can provide the basis for additional collaboration, mentorship, and increase the overall innovation at an institution. We recognize our fellow senior members and chapters of excellence at induction at our annual conference. We have induction ceremonies for our fellows and senior members and a chapter of excellence award that is given at the annual conference. In addition to this, the annual conference brings together the brightest minds to share best practices in research, innovation, patenting, tech transfer, and more. Speakers include thought leaders, government officials, patent office representatives, university leaders, and top inventors and researchers from around the world for impactful discussion and connection. Our upcoming conference is going to be in Atlanta, Georgia this summer, and we're really excited about this conference. It'll have so much, there's so much content we want to bring to it that we're expanding to 3 days from our traditional 2-day conference, and we'll be including excursions into the city itself so we can all really experience everything Atlanta has to offer. There are amazing panelists and influential keynote speakers, so join us in Atlanta. Registration will open in January. Also at our annual conference, we hold our student showcase. We all know investing in the future of invention is critical. NAI does this by featuring young and university inventors in the student showcase. Students apply for the opportunity to share their inventions to NAI members and conference participants. In addition, we now offer a Genspiration Prize to recognize the top inventor in 3 different categories. This prize is awarded at our annual conference. In addition to these programs, we offer many educational programs and opportunities, and I'll talk a little bit about those now. So first up, we have GAIN. GAIN is the Global Academic Invention Network, where our members can give advice and get advice. Originally started as a traditional mentoring platform to pair our experienced inventor community with students, we are growing and launching themed communities and peer networking opportunities to broaden the impact and scope of GAIN. We invite everyone to register for our GAIN platform and start taking advantage of the connection opportunities. You can register by heading to our website, linked at the bottom, academyinventors.org, and clicking on GAIN, and there'll be a location to join them. We also have our IP curriculum and certification process. The current IP curriculum was developed in partnership with the Michelson Institute of IP. It provides a foundation for IP, which is so important to our engineers and scientists entering the workforce and research roles. The course is 12 video modules and 38 lessons with a final exam. Once you pass the final exam, participants are awarded an Innovation Development Certificate from NAI. The course is currently free. There are no fees for lessons, the exam, the certificate, and if you're interested in using it in your classroom, please don't hesitate to reach out for more information. We are also constantly developing more curriculum to meet the needs of the community. Both GAIN and our IP curriculum programs are supported in part by our partnership with the United States Patent and Trademark Office. We also offer video webinar resources. The first one on the list is ScholarShare. You all know what that is because you're here now. We're relaunching and excited to start regularly offering ScholarShare webinars again. After this webinar ends, there'll be a short survey. You guys are the first group to attend our relaunched ScholarShare, and we would be so grateful for your participation in the survey. We need your help to shape the future of ScholarShare, and we value your feedback and assistance. So please share any ideas so we can create a valuable program for you. In addition to ScholarShare, we also have From Campus to Commerce video series, which was developed in partnership with the USPTO. Our first new and relaunched video came out last month, featuring innovations from USF, including tumor-on a disc technology to develop cancer treatments. Check it out. Next up, we have our Invention Insider series, which is also supported by the USPTO. By sharing the stories and insights of luminaries in the innovation ecosystem, the series aims to recognize inventors from all backgrounds and communities, providing a more personal look at what impact being an inventor can have. You can find these stories on our website under the newsroom. Next up is our T&I journal, Technology and Innovation. It focuses on publications related to transformative technology and academic innovation. We're currently transitioning the T&I journal to a new publisher, Taylor Francis, so be on the lookout soon for calls for papers for our future issues. We also publish 3 patent rankings each year in the first half of the year. We aim to highlight the vital role patents play in translating university research and innovation, as well as the important role academic institutions play in the innovation ecosystem. We create lists looking at the worldwide universities, US universities, and nonprofit research organizations and government agencies. You can find all 3 of these lists on our website if you'd like to look up your own organization and see where you land. So many of the programs I talked about today are exclusively available to our member institutions, which include many prestigious academic institutions. GAIN, our mentoring platform, From Campus to Conference spotlights, the senior member program, the chapter program, discounted publication rights for our T&I journal, including opportunities for your members and institution to be spotlighted in our newsletter, social media, et cetera, are all available to our member institutions. Without the support of our member institutions, NAI couldn't offer all of this programming and support the academic, nonprofit, and government agency innovation ecosystem. For those of you on the call who are currently affiliated with member institutions, thank you for your support. For those who would like to join this illustrious group of institutions, please check out our website and reach out. We're happy to discuss. So that's it for me on the programs. We've got 5 minutes left, so I'm gonna take a short break for if there are any questions. Otherwise, I'll switch back to Anton's slides to talk a little bit more about patenting. But you can find out more about all the programs I briefly touched on our website, and I'll drop the link in the chat shortly. Please visit and take a look around. You can also contact me. My email address is there on the screen with any questions for more information or to get involved in our programs. I'd love to hear from you. This ScholarShare webinar will be posted on our YouTube channel, and we'll email the link to our participants. And as mentioned before, there'll be a 5-question survey afterwards that we'd really appreciate your help on. So go ahead and type questions in the chat if you have any, and I'm going to switch over to Anton's slides that we can talk about. Hear more from him. Right.
So, Julie, if you want to just go ahead and forward till you see a very old light bulb.
Yes.
There
Here?
we go. Okay. So, going back to patents, the one thing about patents is when people say they want to claim an entire system or entire process, I'm usually a little bit skeptical, because what you really want to be able to do is patent an indispensable cog in a system that probably already exists in some form or another. When Thomas Edison first took up the light bulb, he was obviously incredibly prolific, over 1,000 patents. The light bulb itself had existed for 70 years. So the fact that we would take a glass tube, put it in a vacuum, illuminate with a galvanic current, and create some artificial light was nothing more than a laboratory experiment at the time. And the longest lasting light bulb at that time lasted about 13.5 hours. So in 1879, Thomas Edison, by modifying the carbonized bamboo filament, was able to get that to last 40 hours. And then within a year of that, got it to last 1,200 hours. And think about this, at the time, why would anybody buy a light bulb that only lasted 13 hours? You had the gas lamp worked fine, it was already there and it was existing. But when you had an electric illumination and it could last 1,200 hours, what do we call that type of technology? It's disruptive, right? And so we go to the next slide. What we're looking for when you're trying to evaluate, is this an invention I should pursue? We are looking at the delta. We have a state of the art, which is a line in the sand in the system. And then we say, what have we done beyond it? And a lot of people know this. My wife nicknames me the dream squasher. She nicknames me this because I'm usually very skeptical, and I'm skeptical on behalf of my clients that include universities, because unless there is a significant delta over the state of the art, why are we even doing the patent? So if you want to have something that is valuable, that a disruptive technology, and we do that for 2 big reasons, and it's at your birth and your death. Your birth is your startup. In your startup, you have no clients, you have no customers, you have very little infrastructure. The only thing you have is your idea. And your idea is collateral if you put it into the patent system. And then the VCs, the bankers, are able to put a security interest on your early stage technology that's in your mind. It's in the patent system. That's at your birth. It has value. And then, and we don't call this the death because hopefully you're going to be retiring to a beach somewhere, but your exit strategy, you should envision a huge conference table in a lawyer's office, and they're doing due diligence and they're looking at everything that your startup that is now a full-fledged company is exiting with. And if you have a substantial patent, intellectual property portfolio for that matter, it should include trademarks, it might include copyrights, but if you're a technology company, to be able to say, my company is the only one that can practice this technology for perhaps decades, then it's going to change the dynamics of that exit. It's going to change the dynamics of what your company is valued with. So your patents are there when you're born and they're there when you die. And if you are good at choosing the winners and losers, and sometimes that can feel like a lottery, but look to the quantitative delta in the change of the technology. And the more that you can quantify it, the greater that value. If somebody says they could increase the fuel efficiency of a jet engine by 0.5%, that's $1 billion invention. So we go to the next one. And we're going to skip through the unpatentable slides, and I'm just going to let you know formulas, nuclear weapons, methods of surgery on a cadaver, animal or human, unpatentable. Keep switching. This was going to be design patents, and we're going to go to patent claims. When somebody looks at a patent, and you, in particularly a patent attorney like Julie will like look at the front cover and go, ah, and then she's going to flip all the way to the back to the numbered paragraphs in the back. And the first thing she's going to do if she's skeptical, is the first claim 2 pages long? And she's going to look at the scope. So patent claims are kind of a balance because you want them to be vague enough in a way so that people can't design around them and they will infringe on different ways of doing it that stay within the philosophy. But they've got to be specific enough that they're going to get patented in the first place and they're going to be found valid. So we go to this next slide. These are what these claims look like. They're the most boring part of the patent. There's not even figures or anybody's name or anything like that, but is the first thing that a patent attorney will look at. And it's really the most value a patent attorney brings to a patent application. So many clients and faculty give us these huge manuscripts, and then they look at it and they go, well, you know, this patent application, you know, it's virtually all my technology. And I go, yeah, you know, you're looking at the patent claims. And patent attorneys have to be clairvoyant into 20 plus years and think, how would somebody navigate and design around these claims? And we'll go to the next slide. So the claims are the pinnacle. That's the top of the pyramid, and the specification, the figures, the drawings, all that is there to support the claims. And there's 2 ways that you can have a valid patent. One is constructive reduction to practice, and that's when everything in my patent application teaches somebody how to do it and they don't have to guess or experiment unduly. And then there's actual reduction, which is where you actually create the prototype, and of course you still talk about it, but actual reduction can be necessary in things like life sciences, the unpredictable arts, because this composition, maybe it cured cancer in a rat, but it doesn't in a human. And we go to the next slide. Probably one of the most important things for inventors to know about are bars to patentability. So if you present at a conference in August 31st of 2023, and you haven't done any filings, that technology is now in the public domain and you are not going to be able to patent it. Same thing with the publication. You have a 1-year statutory bar grace period in the United States from the date of publication. And of course, we can get into the rabbit hole. Is it a PhD thesis that's indexed in the card catalog that every patent bar examination asks you about? But if it's reasonably accessible, then that 1-year publication is going to discharge into the public domain and you've lost your patent rights. The same thing goes when you try to sell something and here's the mind blower. You could have a non-disclosure with your potential buyer or licensee of the technology, but you made a legitimate offer to sell the patent. Even under a non-disclosure agreement, you will trigger a statutory bar. Now, the US is relatively forgiving that we give you 1 year, but since 2013, now it's a race to the patent office, the first legitimate inventor to file. So inventions are not like fine wine. They don't get better over time. So it's important to get them on file. Most countries have an absolute novelty requirement, which means you disclose it on day 1, you're done. You have to get that patent on file early. So big things like pharmaceutical companies and things like that, they're very, very intense about getting their patents on file. So next slide. Patent examiners are the ones that analyze claims. When it goes through that process, then they enjoy that clear and convincing standard that the Supreme Court talked about or ruled in June 9th of 2011. Examiners one trick I'll leave the attendees with is when you get a first office action from a patent examiner, take their name and Google patent examiner and put their name in. And the very first result you'll get are the analytics of that patent examiner, because patents are so structured and they're amazing for large language models because they're self tagged. And so we know if a patent issues, we know if a patent is rejected or a patent application is rejected. So we can kind of figure out how difficult these examiners are, how easy these examiners are. They're all human beings and they're all different. We have about 8,441 patent examiners right now at the US Patent Office, and they're trying to hire more. They're all individual technical experts within their field that are assigned a group art unit. And some are going to be more difficult than others. So first time you get an office action, you can find out, is this going to be a tough road or is this going to be an easy one? Next slide. So patent claims use unique language. We look at something as simple as a pencil. You know, this is a substantially rigid elongate member having a pigment core extending down the longitudinal axis, where the longitudinal member is carvable to expose the pigment core, whereupon it makes marks on a surface medium upon physical abrasion. So we use very specific claim language, and every single term that somebody like Julie or myself will use is heavily thought out. So we're going to do very quick, 5 minutes, at most 3 minutes, and learn how to interpret a patent claim. All right, so let's just take a bucket. So next slide is our patent claim. So we have a device for carrying liquids. It's a bucket, it's a handle which depends from the bucket, and a cushioning means attached to the handle. All right, so those are our claims. We would say they have 3 limitations. We got to have a bucket, we got to have a handle, and we have to have a cushion. If we don't have those things, then there's not infringement. The thing about a patent claim is everything in the claim has to be present in the accused article for there to be infringement. Okay, so we have a bucket, a handle, and a cushion. Let's look at potentially infringing articles. So let's just bring up all of those embodiments right now. We have embodiment 1, 2, 3, and 4, and then we'll go ahead and put a poll. So remember, the patent claim was the bucket, the handle, and the cushion. So which one of these, if any, infringe? I don't know if a poll came up or not, but if it's not coming up, let's look at embodiment 1. What is missing? We're missing the handle and we're missing the cushion. So there can be no infringement. Embodiment 2, we're missing the cushion. There's no infringement. Embodiment 3, all 3 elements exist, so there will be infringement. Embodiment 4, we never said that the bucket had to be made out of wood. In fact, we would like our language as patent attorneys to be agnostic as possible. And if there's not a requirement for there to be a material limitation, we want it to be plastic or metal or wood. So embodiment 4 would infringe as well. So next slide. That was that was my poll. So we obviously know. Now, what if we do a new embodiment, and here we create a sensor that's embedded into the bucket that will let you know if the water is potable or not? Would this infringe? And we'll go to the next slide. And so does this infringe? Now, if we look at it, it would not, because there's no cushion on there. But even if we added if we go back one slide, even if we added the potable water detector, there would still be infringement, because we're using special terminology. We're using a special word, and we'll keep going forward again. And that is the word comprising. So comprising means all these things are included in the accused device and anything extra as well. Consisting means it can only include these things and nothing else. And what will happen is, if you're not represented by a patent attorney, sometimes helpful examiners will say, well, I'll allow your case, but I'm going to have you amend it to consisting. And you think comprising, consisting, tomato, tomato, all sounds good. I'm getting my allowance and I'm super excited. But here are the implications. We go to the next slide. So if we claim this, that was consisting, that means we can only have a bucket, we can only have a handle, and we can only have a cushion. So if we go to the next slide and we look at this where we've added the potable water detector, because we have used this crazy consisting language, that means that this would actually not infringe, and it would be trivial to always circumvent infringement just by adding something in addition to those three elements. And so, next slide. So again, a patent attorney like Julie or myself, we flip to the claims and we look, how good are these claims? So when we see things in the claims that are like unnecessary quantitative limitations, that something has to be a certain dimension, and it's not even a range of dimension, and it's exact, these are big red flags for the patent to not really have a lot of enforceability. So, the whole point on this would be on patent, you're really thinking critically. You're really trying to think ahead of how somebody would try to design around it. And you have to be very, very exacting with your language. So I think that would be it for this. If we are open to any questions, we still have maybe a minute or so, right?
Yes. But I don't see any questions, so I think we might be good. Well, as I said, thank you very much. You can feel free to email me after our website is in the chat, and I will put my my email in the chat as well. So feel free to reach out, and thank you everybody for coming today. And I hope you enjoyed the presentation as much as I did. Thank you.